The broadcast is now starting. All attendees are in listen-only mode.
Hi, everybody. This is Sharon from the Alumni Office at William Patterson University, and I want to welcome you to our webinar, Estate Planning and Wills, What You Need to Know, presented by WP alumna Mariya Gonor, class of 2009, and her associate, John B. Stephenson. Okay, if you're like most people, similar to procrastinating that visit to the dentist, you probably have been putting off creating an estate plan. Over the last 3 weeks, a great number of people have reached out to Mariya and John seeking advice and guidance on that very issue. So while this quarantine is forcing us to stay indoors, it's also forcing us to press pause on our busy lives and giving us a little bit of free time, which could and should be used to plan effectively for one's future. A good estate plan is much more than a simple instruction of who gets grandma's heirloom ring. It's important to have your estate plan in order no matter what stage of life you are in. And some examples, did you know if you will be able to get your boyfriend of 7 years medical information if he gets sick? And what happens if your grandparent passes without a will? So before I introduce today's presenters, I'd like to go over how this webinar is working for those of you who have not attended one of our presentations before. First of all, you should be able to see the presentation right now on your computer screen. It says Estate Planning presented by Mariya Gonor and John Stephenson. And you should also be able to hear me speaking. I hope you can. Feel free to ask questions by typing them in. On your dashboard, you'll see a little questions tab. You can type anything in there if you have a statement, you want to say something, or if you have questions. We will be monitoring the questions, but the presentation runs about 45 minutes, and we will try to get to questions. Any questions we don't get to in today's webinar will be sent to the presenters, and you can reach out to them individually, or they can reach out to you. So now I would like to introduce today's topic and speakers. Mariya Gonor is a 2009 graduate of William Patterson, and she is an associate with the law firm of Beatty Padovano, LLC. She's a litigator who focuses her practice on estate, employment, and corporate litigation. John Stephenson is an associate in the firm's tax and estate planning department. His practice focuses on estate planning, estate and trust administration, and charitable planning, as well as related estate litigation. He advises clients in the creation and implementation of estate plans that effectively represent his clients' personal wishes with respect to the disposition of assets while employing wealth preservation strategies. In today's webinar, Mariya and John will discuss wills, the various forms of trusts, advanced directives for healthcare, power of attorney instruments, and how these various planning techniques can help you protect your loved ones and your assets. They will also cover the probate process in New Jersey and what happens if you do not have an estate plan, and give you practical advice on how to begin your estate planning journey. So now I would like to introduce our presenters, Mariya Gonor and John Stephenson. Thank you.
Thank you so much, Sharon, and good afternoon, everyone.
Good afternoon.
Hope you can hear us both okay.
And thanks for everyone for taking time out of your busy schedule that I'm sure everyone has during this quarantine to listen to us for about an hour.
Yeah, we're going to throw a bunch of legal terms at you, but hopefully we will make it simple and somewhat entertaining, even though the topic is very, very serious and could be a little bit gloomy.
Yeah, and to that effect, we're going to be going over a lot of information, a lot of stuff you might have heard before, a lot of stuff you haven't heard before in a relatively short period of time. So don't worry if you miss anything. As Sharon said, we're going to be getting questions from you during this and after this. Our contact information will be listed at the end of our presentation. So if you miss anything, if you have a question during or something pops in your head afterwards, we will get to you.
And in case some of you are wondering why a litigator is giving you a presentation on how to create a transactional document, the answer is simple. When estates and trusts end up in litigation, you know that someone did something wrong. So while John is going to cover good practices in connection with estate planning, I'm going to give you examples and horror stories of bad practices and what not to do. Now, before we dive in into our...
I'm sorry, this is Sharon. Some people are saying that your voices are not clear.
Oh, is this better?
I'm going to go as close to the mic as possible.
Literally sitting on top of my laptop. I don't think I can get any closer.
Okay.
Is this better?
We'll try this. We'll see if this is better. Let us know, please.
Okay, so a little disclaimer before we dive into the seminar. Our lawyers made us do it. This seminar is presented for informational purposes only. It is not meant to provide anyone with any specific legal advice or guidance. Each specific estate plan is a complicated and fact-sensitive process. For that reason, you should always seek counsel from an experienced attorney in connection to your individual needs and individual documents and what have you. Again, this is just general overview, not meant to be specific legal advice. And as John stated before, we will provide our contact information at the end of the seminar. So if you have a specific question, feel free to email us. But we are not going to be addressing any specific question targeted to any particular document for any specific person in the seminar. Okay, so John, what are the two certain things in life?
I believe that it was Benjamin Franklin who said the only two certainties are death and taxes.
Ben Franklin, really? I thought it was Big Bird.
Sesame Street? I don't think so.
Well, a good estate plan can help you with both tax planning during your lifetime and also how to take care of your loved ones after you pass away. What is an estate plan, John?
So an estate plan is essentially, in the most simple way to describe it, a map of how you want your assets to pass upon your death. However, a good estate plan is much more and consists of much more. It can include instructions for your care should you become disabled. It can name a guardian and an inheritance manager or a trustee for minor children. It can provide family members with special needs without disrupting governmental benefits.
So in connection with special needs, let me give you a great example of a case that we handled recently for a client of ours. So this client, let's say her name is Alice, contacted us because she has two brothers. One of her brothers, let's call him Jimmy, has an IQ of 70, right? So he is a great kid. He works really, really hard, but his job is a minimum wage job. He can't get anything else. And in connection with that job, he doesn't receive any benefits, but he is receiving benefits from the state. He's receiving some housing assistance, and he is receiving some healthcare assistance. I believe he has Medicaid. And so Alice became very concerned because when their grandpa passed away, he left a lot of assets to their dad. And now they're worried about their dad's estate planning because each sibling would inherit a lot of money. And that could disqualify Jimmy from the great benefits that he's receiving. And although the inheritance is sizable for the purposes of, qualification for state assistance, it is certainly not sizable enough to take care of him for the rest of his life. So in that connection, we sat down with Alice and planned out a special needs trust, and we planned out documents that would allow Jimmy to receive the inheritance, but also not lose his benefits. Another important element of estate planning is Medicaid planning, and we get calls about that all the time. I'm sure you've heard horror stories of people becoming disabled or parents becoming disabled and then losing their primary asset, their house, using that asset to pay for long-term medical care. Medicaid planning could prevent that. Importantly, however, you have to start Medicaid planning really early on. And why is that, John?
Well, when an application for Medicaid is made, the Medicaid board will look 60 months back in the past and look at all transfers of assets during that period of time. So 60 months is 5 years. It's a long time to be considering Medicaid. So you really do want to make these plans far in advance so you're not penalized when the time comes.
Right. Any effective estate plan requires actual planning, right? It's in the term itself. And the sooner you start doing it, the better.
So, right, some additional reasons, or some additional aspects of estate planning can also, be to provide for loved ones who might, be irresponsible with money, or who may need future protection from creditors or divorce. You definitely want to consider an estate plan to provide for the transfer of your business at your retirement or disability or death. An estate plan can also be used and is used by many to minimize taxes, court costs that you may otherwise incur, and unnecessary legal fees, if you didn't have an estate plan. Normally, estate planning, it's not one of the documents that we'll go over, but an aspect you should consider when planning is life insurance to provide for your family at death, disability insurance, disability income insurance rather, to provide to replace your income if you can't work due to illness or injury, and long-term care insurance to help pay for your care in case of an extended illness or injury. And I should note, I'll probably say this again, so excuse me, but estate planning is an ongoing process. It's not a one-time event. Your plan should be reviewed and updated as your family and financial situations change over time.
Mariya and John?
Yeah.
Hi, it's Sharon. People are still saying it's a little choppy. Do you have two computers going or one?
No, just the one.
Okay. And also,
Just one.
on your screen, you have your microphone settings. Maybe you could change the microphone settings.
Let's see.
I just want to make sure everyone's well.
360 degree and around the PC. So
Let's try that.
try that.
Let's try that.
Yeah.
Oh, okay. Well, hopefully this is better, and we're also closer to our computer. So hope you guys can hear us. If not, again, we will provide our.
Much better.
Say again? Much better. Okay, good.
Yeah,
Excellent. All right. But again, you will have our contact information. So if you have any questions, if you missed something, don't hesitate to email either one of us, both of us, what have you.
And thank you, Stephen,
All right.
for that suggestion. Thank you.
Oh, yes, yeah, exactly. All right. So what is included in a good estate plan? Oh, no, it doesn't work. There you go. All right, let's go over some of the documents that could be included in an estate plan. John, what is a will?
So the will is going to be your foundation, your building block of every estate plan. It in the simplest terms, directs where your property should go. It names an executor, a testamentary trustee. That's a trust that's created by the will itself. And it can name guardian for minor children. It can accomplish many other goals, such as minimizing taxes as well.
Okay, in connection with a will, one of the most important decisions that you're going to make is selecting your executor. An executor is essentially a person who is tasked with administering whatever assets you leave behind pursuant to the instructions that you left in your will. A lot of people approach this selection process in a very optimistic manner. And I'll give you an example of a case that I've been handling since 2016, where the parent who passed away had 3 children. Those 3 children never got along, ever. But the parents hoped that their death would bring them together, and so they named all 3 of them as co-executors of their estates. What that means essentially is that all 3 of them are in charge of making the decisions on behalf of the estate that's left behind. Sometimes your will can designate that your multiple executors will make decisions by vote, right? So 2 against 1, or that all decisions have to be made by unanimous consent. In this situation, it was 2 against 1 that was enough. But because they could never get along before the death of their parents, the death and prolonged illness of one of them only exacerbated the problems that these 3 siblings had. As a result, every little thing that needs to be done on behalf of this estate requires participation of attorneys who represent these co-executors. So from 2016 to today, the estate is not settled yet. And on top of that, I think they've spent probably $500,000 collectively on legal fees. Indeed, the other day I had to write an email asking to have a stamp included next time they want my client to sign a check. You know what that means though, right? A stamp is about 50 cents. The 10 minutes of my time is roughly $37. So these are the kind of things that you may be forced to deal with if you do not properly plan for executors. It has to be not an optimistic decision, but a reasonable one. An executor doesn't have to be a family member. It could be an accountant that you trust. It could be an attorney that you trust. Now, if you select someone like an accountant and attorney, make sure you speak with them first, obviously, and then make sure that they're interested and willing to serve as an executor. And it may cost you a little bit extra in terms of the administration, but it may be saving you a whole lot of money in the long run if done correctly.
Absolutely.
Now, with respect to trusts are not just for trust fund babies. You don't have to be extremely wealthy to have a trust. John, can you explain what a trust is?
Sure. So a trust is a very, very versatile estate planning tool. There are too many types to get into in this short seminar. You could spend an entire day, if not more than one day, going over the different types of trusts and how they apply.
Indeed, we spent months in law school going over different types of trusts and how they apply. But
that's true. But if you have additional questions, again, you'll be able to ask them. Contact us. I'll be happy to discuss your particular situation and what might apply to it. Trusts are legal entities that hold property. In the eyes of the law, they're just like you and me. They're individuals. The parties to a trust are the grantor, the person who physically puts the property into trust, the trustee, who is the person who's going to be in charge of administering the trust on a day-to-day basis, and the beneficiaries, the lucky ones, the ones who get the trust corpus and income when all is said and done. There are both living trusts and testamentary trusts. Testamentary trusts are trusts that are created by your will. There are revocable trusts and irrevocable trusts. The simplest way of stating the difference between a revocable trust and an irrevocable trust is that an irrevocable trust can be changed at any time. An irrevocable trust describes a trust that cannot be modified after it is created without the consent of all beneficiaries. So let's say you put your house into a revocable trust and a couple of years later, you don't want it in there anymore. You can just remove it and cancel the trust. If you put it into an irrevocable trust, however, that is not an option unless you have the consent of all beneficiaries at the very least. It should be noted that the protection levels between a revocable trust and an irrevocable trust are very different. Many people will use trusts to protect from creditors, to protect from taxes. A revocable trust won't accomplish that. It's good for other things, such as avoiding probate or avoiding ancillary probate if you have property outside of New Jersey or in several states, but it won't provide the protection level that an irrevocable trust will.
And as I started in the beginning, I said that trust funds are not for trust fund babies only. And indeed, for people who are in the middle class or upper middle class, trust is a particularly important instrument in estate planning. As I mentioned before, an example of Alice and Jimmy, we created a special needs trust for Jimmy with Alice as the trustee, right? So another example is with grandparents. So recently we were contacted by Anna, a woman who's 65 years old who has a 3-year-old granddaughter. She loves her daughter, but she does not particularly trust her son-in-law. And so when we were drafting her will, she wanted to come up with a creative way to pass along all of her assets, which are about $500,000-$600,000 because she owns a house and she has a couple of IRAs here and there and a couple of accounts. She wants all of those assets to go to her grandchild. The thing is, if she's 65 now and her grandchild's 3, she doesn't want a situation where an 18-year-old will inherit all that money outright, right? It may be, actually, it might not even be an 18-year-old, right? You may have a 20-year-old, or you've probably heard that the 30 is the new 20. So you don't want a kid who's going off to college to inherit, it may not even be that much money, maybe $50,000. You don't want them to inherit it outright and spend it on a great vacation or a great gap year. Instead, you want to make sure that the money is used for the necessities such as education, health, maintenance. So a trust is a great tool to accomplish that. So coming back to my example with Anna, because she didn't want her son-in-law to ever kind of have his hands on anything that the granddaughter may inherit, she created a testamentary trust. So what happens when Anna dies, all of the assets that would go to her granddaughter is going to go to a trust. And then her daughter is named the trustee. The trust sets forth very specific instructions on how the money can be spent, because Anna didn't want her daughter to throw like an extravagant wedding for her granddaughter. Instead, she wants to make sure that the money goes towards her education, health, maintenance. And so the trust provides that the trustee can only spend money in that fashion, right? So the other thing that she did is, God forbid something should happen to her daughter, she named an alternative trustee. So if her daughter cannot serve, she named me, the attorney, as an alternative trustee to serve on behalf of her granddaughter. This way, the son-in-law, to whom she doesn't trust, will never be able to actually get his hands on the money outright and spend it as he wishes. Another very important document in connection with your estate plan is a healthcare proxy. John, what's a healthcare proxy?
So healthcare proxy, healthcare declaration, healthcare power of attorney, living will, as it's referred to in New Jersey a lot, all the same document. This is a document that puts your wishes with respect to your care in writing. It allows you to designate an agent to make decisions on your behalf. And it authorizes your agent to access medical information and speak to your physician. So, you know, in that respect, it'll normally include a HIPAA release, which is very important, as well as, you know, it'll have a do not resuscitate, or, you know, it'll leave that up to your agent, however you want to, whatever your wishes are, we can word it however you'd like.
And it is particularly important because, you know, if you don't have this document, the law will appoint an agent for you. And whoever gets appointed by law may not necessarily be a person you want to serve and make your healthcare decisions for you. So for instance, if you are married to someone who is not great with stress and healthcare decisions like that, maybe you want to appoint one of your kids to serve. In another example, like if you're unmarried, for instance, and you don't want your parent to be making these decisions for you, you want your significant other to make these decisions for you, but you are not married, you would want to designate them as an agent to make your healthcare decisions.
And these documents are not just for people that are, you know, getting ready to go into surgery, or, you know, ill or elderly. You know, I think it's really more important for people that are, you know, have children that are 17, approaching 18, getting ready to go off to college. For those children that have these sorts of documents, imagine getting a call one day as a parent that, you know, your child was involved in an accident, you know, several states away, several hours away. You go to try and speak to physicians or access medical records, and because in the eyes of the law, your child is an adult, you're not granted that access. That would not be a good situation to be in, and unfortunately, I've seen a lot of people in that situation. So that's why having a living will for someone younger is really very important as well.
The next document is called the power of attorney. If any one of you has ever purchased a car, you have executed a form of power of attorney. Hopefully, you executed what's called a limited power of attorney, authorizing the dealership to get your registration documents on your behalf. Although, I mean, if you went to a particularly shady dealership, it might have been a general power of attorney, and now you own a bunch of cars from another state. I don't know. That really underscores the importance of reading the documents you sign. But jokes aside, a power of attorney designates a specific person to act as your agent, right? And that agent can do a lot of things on your behalf. You can limit the things that this agent can do, as in my example, only get your car registered, or it could be a general power of attorney, basically authorizing that person to step into your shoes and act on your behalf whenever. I'll give you an example from my personal life. My brother is in the Navy, and when he goes on deployment, generally he forgets to do a couple of things, maybe suspend his cell phone plan or suspend his internet provider, right? And every time he leaves, he executes a general power of attorney naming me as an agent to act on his behalf. So I can do all of the things that he forgets to do or deal with the important financial issues that may arise while he's unavailable due to deployment. In addition, power of attorney could be immediate, such as general one, so that the person can act on your behalf immediately, or it can become a springing one, which means that a person can only start acting on your behalf upon a happening of a particular event. Generally, we do springing power of attorneys in connection with incapacity, right? So should you be unable to act on your own behalf because of some incapacity, the person you designated will act for you.
Right, and the standard is typically incapacity found after the examination of two attending physicians. So, that is a good thing and a bad thing because it requires that additional step and will require some additional time. And God forbid, doctors disagree upon the capacity of the individual. You might not get the agent to act in a timely manner. So, we do more general durable powers of attorney. However, if you're not confident enough to have someone have that sort of power over your assets and being able to step into your shoes, a springing power of attorney is a great alternative.
Right, and like John said, you can make the springing power of attorney based on the opinion of two physicians. You can make it based on an opinion of one physician. You can make it whichever way you want, because when you draft your own documents, you are in complete control over what you want to happen within reason and within the legal framework. But for instance, if you don't have a power of attorney though, and you become incapacitated, and we frequently see this with people who suffer from Alzheimer's or dementia or other mental illness, if you don't have a power of attorney, what would happen is you would have to apply to court for what's called a guardianship, right?
Well, the person who would conceivably be your agent or your caregiver would have to make an application to the court to be appointed your guardian. And this is something that I've represented individuals in quite a bit. It can be a lengthy and costly process, especially if there is some sort of challenge. So two individuals that are fighting over who should be the guardian. You're not only paying for your attorney to represent you, but the court will appoint an attorney to represent the alleged incapacitated individual. A guardian ad litem is what that is referred to. And you will be responsible for those attorney fees as well. An unchallenged, very streamlined guardianship proceeding can easily cost the applicant, between $5,000 and $7,000. There's a lot of documents that need to be put together. There's a statement of assets.
And once you're appointed guardian, you're required to file periodic statements with the court summarizing what you've done with person's assets. But a power of attorney can do away with that requirement, making it easier for you to serve as an agent for the person. Now, what happens if you do not have an estate plan? So the good news is you don't automatically forfeit all of your assets. Instead, there are statutes in various states called intestacy statutes. In New Jersey, the citation is listed below. Essentially, that means that the state of New Jersey has written a will for you. John?
Which sounds great, but maybe it's not. They have written a will for you, but that statutory distribution scheme may very well not be how you would like your assets to pass. In New Jersey, it really depends upon who is surviving, what your marital situation is, what your child, how many children, not how many children, but if you have children. And the process of getting someone appointed to administer your estate for an intestate administration is considerably different from probate. Someone will need to apply to the surrogate's court to be appointed the administrator. This will delay the opening of an estate up to several months. It will be an additional cost, and the administrator will need to be bonded. Unless they are the sole beneficiary, which is really the only situation where I see bond being waived. And you're probably saying, what's bond? Bond is essentially an insurance policy if the administrator runs away with all the estate assets, leaving the beneficiaries with nothing. Bond is increasingly difficult to get if you have, or the person applying to the administrator has any sort of bankruptcy, poor credit history, criminal history, which I'm sure is nobody listening to this, but that would prevent you from being bonded. Also, like any insurance policy, expect to pay a premium, and depending upon the size of the estate, it can be significant.
Right, and when you have a will and you name an executor, in your will you can do away with the requirement of having a bond. Now, let's give you a concrete example what would happen to someone without an estate plan, right? So let's take me for an example. I am an unmarried person with assets, right? Because I am unmarried and I have no children, under the intestacy laws, everything I own would go to my dad, to my parent. Now, in my specific situation, I have 3 siblings. I have a mom who lives in another country, and I have some friends that are very dear to me who I am so close with that I would call them my, siblings. So if I do not have an estate plan, my dad gets to inherit everything and distribute it as he sees fit, right? And that may not be something that I want happening. For instance, I would want my extensive purse collection to go to my best friend, and I would want to specify that. I would want a trust for one of my brothers because I don't particularly trust him to handle the money properly. I would also want to make sure that my mom, who lives in another country, gets to inherit some of my assets, right? And in the absence of a will or an estate plan, that won't happen.
You forgot about your dog.
Oh my God, yes, my dog. What happens to my dog?
It goes to me, right?
Probably, I don't know.
Okay, good.
Maybe. But the point is that the intestacy laws were written by a bunch of old, likely white men who decided that one size fits all, right? But frequently it doesn't. So, who needs an estate plan? The simple answer is really everyone. A common misconception is that estate planning is for older people or for exceedingly rich people, but that is simply not true. We have a picture of Modern Family here, and I think this really drives the point home. Family does not look the same today as it did 50 years ago or 40 years ago when these intestacy laws were written. Families are greatly diverse and very different. You have people who live together but are unmarried. You have people who are on their second marriages. You have people who be in the same-sex relationship living in a state that does not provide for legality of a same-sex marriage, right? So in most circumstances, intestacy laws may not be what you want your ultimate plan to look like, especially if you're in a position of Jay. Let's take Jay for an example, right? If he wants to have his grandchildren inherit something, in the absence of a will providing for that, intestacy laws won't accommodate those wishes.
Right. So yeah, I just want to, recap, drive home a couple of points Mariya just made. A lot of people think estate planning is for elderly or retired individuals. It is not. We can't successfully predict how long we will live. Illness and accidents happen. Unfortunately, we are all being reminded all too well of that right now with the current pandemic. Again, estate planning, not just for wealthy individuals. While it is true that people that have built up a significant amount of wealth over their lives do often think more about how to preserve it by avoiding taxes and protecting assets for future generations, I would argue that a good estate plan means more to families with, modest or middle class assets, because those families can have, can really afford to lose the least. And again, yes, the diversity amongst the modern family structures and ever-changing legal framework governing, same-sex couples and unmarried couples, it is important to have updated advice on the manner in which estate planning arrangements can be implemented. If you're unmarried but living with someone cohabitating for a long time, that cohabitating partner will have no rights upon your death.
And let me stress this again, absolutely no legal rights. So you may be living with someone for 10 years, right? You are as good as married, but you just never got married. For whatever reason, you decided not to do that. Your partner will have zero legal rights. And it applies in terms of inheritance. They have no rights to inherit from you. But more importantly, and I think a scarier thought, is that that person has no legal rights to your medical information and to your medical decision making. You may be estranged from your parents or your siblings, and those people are going to be called upon to make medical decisions for you, not your partner. It is particularly important for parents with young children to have an estate plan because of all of the issues that we've discussed. You want to make sure that you name a proper guardian for your kids. Let's go back to your example of Anna. She's 65 years old. Her daughter is, I believe, 36, 37. Our generation, generally, not always, but generally, has children at an older age than generations before us. So while in the past, a guardian was an easy answer because you would just appoint one of your parents, the kid's grandparent, to serve. Now that may not be feasible because by the time child is 15, the grandparent may be 75 or 80 and not unwilling, but just unable to take on the responsibility of raising a young child. So you need to sit down and have a very serious conversation with your partner or with your wife and whoever you want to serve as a guardian for the kid should something happen to them. Maybe you have siblings, but you don't trust them to do it. Again, these are the conversations that need to happen, especially for young parents with young children. Trusts need to be created, all that other stuff. And in fact, you can name one person as a guardian and then another person as a trustee, because maybe you trust the guardian to raise your kid right, but maybe they're not particularly responsible with money, right? So all of these decisions should be made by you early on, rather than by someone else for you.
Right. And those are things, having a guardian appointed, having a trustee appointed for a minor child. You hear, a trust being created. We're not talking about, you creating several planning documents at this point in time. There's a time and a place for that. Most of what, many people will need to accomplish can be done in one will. We can work trust provisions into a will. So a trust will be created upon the death of the testator, the person who created the will. And you don't need any separate documents.
Right, and I think we'll touch upon that in a little bit more detail further on when we talk about the cost of an estate plan, because again, as we're talking at you and mentioning all these various documents, you must be thinking, oh my God, dollar signs, right? Not necessarily. Again, there is no one size fits all. The idea of an estate planning is just that, planning. Not necessarily spending a whole lot of money on it. Now, the next category of people who need to think of an estate plan is unmarried couples. I touched upon that a minute ago. Particularly important to have a good estate plan is for people in their second marriages.
Blended families. So the instance of the actual modern family cast with Jay having children with Gloria, and having children from his past wife. The significant issues can arise under the rules of intestacy under that circumstance. He definitely wants to have planning in place to make his intentions perfectly clear so everyone is treated fairly if that's how he wants to proceed.
Right, so let's take that as a specific example. Let's assume that Jay and Gloria get into a car accident, right? Jay dies immediately and then Gloria survives him by 10 days and then dies. So let's assume also that Jay would want his estate to go equally in equal shares to his children, right? But because Gloria survives him, albeit by 10 days, the bulk of Jay's estate is going to go to her. And then when she dies 10 days later, most of her estate is going to go to her children. So to Manny and to the young kid, I think his name is Joe, I'm not sure.
I think it's Joe.
Okay, so in that scenario, most of Jay's assets goes to Joe and Manny, which is not what he would want to do, right? Let's not mention the fact that it will not go to his children because, his grandchildren, because intestacy laws just simply don't provide for great grandchildren. But That just illustrates a point of how important it is for people in their second marriage to sit down and think about their estate plan. Another thing that people in their second marriage want to think about is their 401ks and pension beneficiary designations. A lot of the times, maybe you worked somewhere for 10, 15 years and you left and you forgot about that IRA a long time ago, but the beneficiary designated on that IRA is your first spouse. You never change that. That first spouse gets to inherit, and to the detriment of your current spouse. The same applies to life insurance policies, right? You might have bought a life insurance policy a long time ago and have long forgotten about who you designated as a beneficiary. Again, it may not be your current spouse. Another important thing in connection with second marriages is taking a look at the settlement agreements for your first divorce.
Absolutely.
A lot of the times, a divorce agreement will require you to name your ex-spouse as a beneficiary in an insurance policy or under a pension plan. That might be just part of the settlement agreement. And those agreements are enforceable after you pass away.
Right. And, you're seeing, well, you're not seeing, but we are seeing as practicing attorneys, more and more of an overlap, between, these sort of matters, ex-wives challenging estates, an overlap between, litigation and the family part, which handles family matters, obviously, and the probate part, which handles estate matters. It's happening more and more, which is why I never create a estate plan for somebody who has been divorced without seeing and going over their marital settlement agreement or property settlement agreement with them.
Right, and that really brings us into our final point, that your estate plan, and I think John has said that early on, and we'll continue saying that throughout this presentation, your estate plan needs to be updated every once in a while. The particular triggers are not necessarily years that have passed, but really major milestones in your life. Did you get married? Did you have another kid? Did you buy property in another state? Did you become wealthier than you were before? Listen, all of these things are great things, but they need to be planned for. Let's say when you created your initial estate plan, you fell into the exceptions for inheritance tax, but then you worked really, really, really hard, and now you Right.
Basically.
Now you're past that threshold, so you want a tax plan to make sure that you minimize your obligations later on.
Right, and another thing that I don't think got onto the slide somehow is if you're a business owner, you definitely want to plan for the succession of your business, whether it be upon retirement or upon your death. We can certainly advise you on that.
So you've decided to make an estate plan. Now what? Before we get into the actual details of preparation, it's important for us to define or explain probate process in New Jersey. John, what's probate?
Okay, so yes, in New Jersey, wills must be probated. Probate refers to the process of filing the will with the surrogate's court in the county in which the testator died, or at least owned property. It's not terribly important for our purposes today, but note that I said for. So let's say that you live and die in Bergen County, but you own property down in Somerset where I live. Your executor would have the option of probating your will in either Bergen or Somerset. Just a neat little fact there for you. After the will is accepted by the surrogate, an executor is appointed. As we briefly touched on before, the executor's job is to collect assets, pay any debts the estate owes, files necessary tax returns, an inheritance tax return potentially in New Jersey, a federal estate tax return, annual income tax returns, and ultimately distribute property to the heirs. Now, that is a very brief, easy sounding description of an executor's duties. Being an executor is a job. It is a job, especially if the estate has a lot of assets and there are difficult beneficiaries. There's a lot of work that can be involved.
There could be a lot of work even when the estate does not have a lot of assets, but a lot of difficult beneficiaries.
Very true.
Really.
Very true.
Probate process generally brings out all of the family drama that you had during lifetime. I mean, probate challenges are as dramatic and as intense as some contentious divorces, really.
Maybe more.
Right. So a clear and well-written will trust document will help with that process immensely.
Right. And typically the process can last, from several months in the best case scenario to typically a year. However, we see many estates go beyond this period. It can be, a year, 2 years, 3 years. It starts getting beyond that. You need to really start looking at what's happening because that's a red flag.
So now that you understand what probate process is, there are two types of assets. There are probate assets and there are non-probate assets. Non-probate assets are those assets that pass to designated beneficiaries automatically upon your death by operation of law. So example of those assets could be specifically drafted deeds to a home, right? Pay on death bank accounts or joint accounts with life of survivorship, life insurance policies, and IRA accounts that have designated survivors. So if you want to bypass, there is a way to design an estate plan that bypasses the probate process almost entirely through cleverly drafted deeds and put together documents. Now, with that though, I must mention to you that if you aim for creating a non-probate asset plan, it is still immensely important to speak to an attorney who knows what they're doing, who understands what's going on, or an accountant. Well, really attorney. Accountants and financial planners are people who are great with this process because they will help you figure out the assets you have and what to do with them and what your options may be. But any good accountant worth his salt will send you to a qualified attorney to deal with this. Just by way of an example, John and I saw a deed to a house recently, just last week, and we could not figure out what would happen upon the death of one of the people who owns this house.
Yeah, without getting into particular details, it was drafted in a really funky way. Funky is not a legal term. It's just, it was done incorrectly. And, really, when these individuals need to administer this estate, it may come down to a judge's decision as to how this is all going to play out if they can't agree. Yeah,
because the house was bought when the family relationship was great, but now the family relationship has deteriorated significantly, and it's guaranteed to have a fight if it's unclear. So that's why it is extremely important to be very, very purposeful with the language that's used in these important documents. So after you've decided to create an estate plan, you have to do some legwork before you even go to an attorney, right? And that legwork is putting together a list of all of the assets you have. Take the time to carefully list everything you own and think of some errand 401k that you might have had someplace. List all of your bank accounts.
Right. So when a client approaches us seeking estate planning, we have this questionnaire that we will initially provide clients with. Right now we're sending it out. More often than not, we would invite a client in to come in and discuss it and do it with us. But given the circumstances, we can't do that at the moment. It's just the nature of the world at the moment. And that will ask for all of your assets. It'll ask for who you want to name executor. It'll ask for your beneficiary designations, as well as basic information about yourself and your immediate family. You do want to have an accurate list of all of your assets. It's very important. For us, we won't know what to do, what your estate plan needs, unless we have an idea of what your general assets are, especially for tax purposes.
The next step is to decide who can be trusted to take care of your estate and naming the executor. I think we touched on that before briefly. It has to be, first of all, you have to have a discussion with this person, right? Make sure that that person is willing to serve. And secondly, the decision has to be a reasonable one. Don't be overly optimistic. Don't try to control your family and try to bring them together. More frequently than not, these attempts will backfire because your family will end up in litigation and, as I said before, spending a lot of money basically trying to do very simple things. So that has to be, again, a reasoned and careful process of selection. After you've decided who will be entrusted with marshaling of the assets, you have to think of beneficiaries. In that connection, obviously, a beneficiary is a person who gets to inherit under the plan. Here, there are two things that you have to keep in mind. Under New Jersey law, you are not allowed to completely disinherit your spouse.
Or minor children.
So you have to take that into account, and consultation with an attorney will help that. Now, the beneficiaries don't have to be people who are related to you, and some estates may benefit from having charitable donations. It may be that your children have done so well that they frankly don't need to inherit from you, right? So you may want to donate to charity, and actually, or you have an adult children who you are not friendly with anymore, and so you don't want to leave anything to them in your will. We had that scenario just recently. So you are able to give to charity. And at this point, actually, if you wanted to think of this great university that you attended that has given you all of the success in life and has brought this amazing presentation to you, you could give to William Patterson as well. And the link below will give you information about charitable giving to William Patterson. John, do you want to add anything about the disinherited spouse or children?
No, just know that, if you're planning, you cannot disinherit a spouse, and you cannot disinherit a minor child. You can disinherit an adult child. There is a statute, it's called the elective share statute for disinherited spouses, which, if they make a claim under that statute, if they're not mentioned in the will, they can receive, up to 1/3 of your augmented estate. And, I'm not going to get into the calculations of what an augmented estate is. It's a very technical statute, but we've litigated these issues before.
Right.
And, it's messy.
Right. Yeah. So it doesn't. If you disinherit your spouse, it doesn't mean that they will file a lawsuit. But we're just talking.
They have that right.
Right. We're just talking about them having that right. So what a lot of people are doing is figuring out what that third share would be and giving the inheritance to the spouse that is approximate to that 1/3 share. Another alternative is really to have a conversation and discussion with your spouse, especially if it's your second marriage, right? There are certain mechanisms by which you can provide for them without making them feel like you didn't care. For instance, a life estate in your marital home, which means that your spouse will live the remainder of their life in your home, and then after they pass, the remainder, it's a legal term, will go to your children. Basically, the children will then inherit the home. So again, it just goes back to how important planning is. Also, you should list out your health goals for your for your healthcare proxy, right? For people who are younger, think of the genetic material you may have stored somewhere. So if you had frozen embryos, what do you want to happen to them? Do you want them to be disposed of? Do you want them to be donated to somebody you know? Do you want them to be donated to science? Do you want your spouse to be able to have your children after you're gone? So all of these things, this is really an example of the new world, because this is not a thing that people would have to think about 50 years ago, but it is a thing that we have to think about now.
And again, these are issues that if not properly planned for, heavily litigated.
Right.
Heavily litigated.
Okay. Should you do it yourself?
The short answer is no. And I guess, pursuant to this question is, really our estate plan is expensive. What's the cost involved? If you don't think you can afford, or if you don't think you have the need for a complex estate plan now, start with what you can afford, start with what you need. For a young family or a single adult, that may just mean a will, term life insurance, power of attorney, and a healthcare declaration. Then as time is going on, you reassess. You let your planning develop and expand as your needs change, and your finances change, your family changes. Do not try to do this yourself to save money. An experienced attorney will be able to provide you critical guidance and peace of mind that your documents are prepared properly. If you want to do it yourself activity, self-publish a book, knit, crochet, do some homemade jewelry, do not do your own estate plan. There has been an emergence of online do-it-yourself estate planning tools by several companies. I won't mention any of them, but several of these platforms have been sued, LegalZoom, I mentioned one, or are being sued for the unauthorized practice of law. In addition, these platforms often do not take into consideration the intricacies of state laws concerning execution and requirements for probate, which, you know, surrogate courts and probate courts can be sticklers for following the rules.
Right. I think out of all the cases that you will see in the court, following a will and following the formalities that surround an execution of a will is one of those leftover anachronisms that the courts really stick with. And the requirements for execution of the will could be complex because, you know, it's not as simple as just having X number of witnesses. Sometimes some people may be disqualified from serving as witnesses. So you have to take all of that into account. And an example of a DIY plan going wrong is this case that we cited here in Ray, the Will of Three. I'm not sure if we're pronouncing the last name right, but here's what happened there. The testator downloaded that one of those fill in the blank forms online, right? He paid whatever that is, like $70, $80, whatever, and filled in the blanks as he thought, basically distributing the assets as he thought he wanted, right? The filled in form, though, was not properly executed. As a result, the court would not allow.
Why wasn't it properly executed?
He didn't have the proper witnesses on the form.
And that's a product of, you know, just downloading a form from one of these form generation websites. They're not providing you instruction on how to execute the document properly.
Right, and again, you know, we haven't used them, so I don't know if they contain some disclaimers requiring you to giving you instructions how to execute. But as I started from the very beginning, a estate plan and execution is extremely complex process, right? So it is best left to professionals who are experts in that field, and I'll touch on that a little bit further down. But at the end of the day, what happened in this case is that this will was not admitted to probate. So the assets could not go as this testator wanted. Instead, intestacy laws kicked in and applied and basically instructed how the assets were going to be forwarded. The problem with this particular form was that it wasn't properly executed, and the other issue was that there wasn't enough information in the testator's own handwriting to qualify for what's known as a holographic will, which is a written out will in the testator's handwriting, which could be admitted to probate in New Jersey. So as a result, and this is a relatively recent case, this is from 2003.
Now, as a result, this will got tossed. His estate was administered in accordance with the rules of intestacy in the state of New Jersey. And this is after his family members had spent tens of thousands of dollars trying to get this will probated through first the probate court and then the Court of Appeals.
Right, so this is the appellate division decision. So this is one of those things where, you know, save it penny wise, dollar foolish. Okay, trusts need to be specific to achieve your goals. There's a typo on the slide, but we'll ignore that. Whenever the courts look at the language of the trust or a will, they scrutinize each and every word and each and every comma. So you have to be very specific with what you want, and you achieve that with good writing. We have been in litigation for 2 years over the term of as a result of the same accident and occurrence, right? So there was a family that were in a tragic car accident where all 3 siblings died as a result of that car accident. But 2 of them died nearly immediately, and then 1 of them survived for over a week and then died. So what was the intent there? The will had a provision that the assets would go in a particular way should they all die as a result of the same occurrence. Was this the same occurrence? Or is the fact that this woman survived another 10 days or a week or what have you changed the intent of how the assets were supposed to go? All of these things were scrutinized by the court, and whatever the courts decided, that's what went, and that may not be what the intent of the testator was in the first place. And for that reason, it is extremely important to go to an experienced trust and estate attorney. You don't want to, like you may have a friend who kind of dabbles in this or who does criminal law and then wills on the side. I mean, look, I'm sure they may be experienced, they may not be, but especially for a more complex estate plan, there's really no substitute for an experienced attorney. In fact, when I'm consulted by clients who have some complex tax needs, I always get John involved, because although I may know a decent amount from my litigation experience, I still want to make sure that someone who deals with this and solely this every day looks at the documents that I've put together, or the documents or the plan that the client would like to put together.
Mariya?
Yes.
I just want to tell you, it's 1:30 now, so some people are leaving, but I know, here we go. I was just going to say there are quite a few questions that if anybody wants to stay, if you are amenable to staying for just a few more minutes to answer a few questions. Otherwise, if you have to leave, thank you for coming. And we've been recording this, so we will put it up on our YouTube, and you can see the end of it if you have to leave. So I just wanted to let anyone know that.
Right, and we also placed our email addresses right here. So if you have any specific questions, feel free to reach out. We'll definitely respond.
Absolutely.
So can we do questions now?
Yeah, absolutely. Go ahead.
There's a few that are already answered. I'm just going to recap things. Somebody did ask about dying intestate, and you covered that very well. So if you had that question, thank you for sending it in, but I think you probably got your answer. There's one gentleman who asked a question about living wills, and that's a very specific question. I asked that prior to this. Feel free, please, to reach out to Mariya or John here, this gentleman, and they can answer that question better. They would need to know more personal information before they could do that.
Right. If you have a question about a specific document, just know that we would need to review that document before giving you an answer.
Yeah, and as I said in the beginning, again, this is, although we are attorneys, although we're discussing legal concepts, this is really not meant to give anyone specific legal guidance. This is just a general introduction and sort of getting you thinking as to what kind of issues you should be really thinking and planning for. Any specific questions should be addressed one-on-one with your attorney.
Okay, and then somebody asked, where do you go to do estate planning? And you did explain that as well. Financial planners, lawyers, you did a very good cover of that.
Right. I would say, start with an attorney. Before you even go to someone, we covered what you should do. So make a list and then start with an attorney. If the attorney needs to get help with a financial planner to kind of get better understanding of what your assets are, that's a possibility. But you always want to start with an experienced estate planning attorney.
Okay. I'm just going to ask this question. It's not really specific, but this person is a widow and wants to know if they can name their two daughters as trustees of the estate as a 50-50 split. Can you do that?
So I think we need to, unwrap the question a little bit. If you're naming, a trustee, which means that there's a trust already involved, you can have co-trustees. If you're creating a will, you can have co-executors. Right. And, co-executors can have, yes, there can be 50-50 beneficiary designations, of course. But I think, the question she might be asking is if she's creating a will and she has two daughters, can they be co-executors? It will be my guess. So yes, they can be co-executors. Just keep in mind, their relationship, where they are geographically, they will need to work together.
Right. And a lot of people shy away from they don't want to not name one kid because they think that child will be offended. So geographical location can be a very simple answer to that, right? So you could name the child that resides in the state as executor and have a conversation with the other child explaining to them that it's not that you don't trust them, it's just that for the purposes of planning and simplicity, it's easier to have an executor who is in state.
Okay. This person said, does the witnesses, what does that have to be from the same state? What if they live in a different state?
No, a witness can be from a different state, that's fine. But when you are executing your last will and testament, everyone needs to be in the same room at the same time. So let's set up the scenario. We have a testator, the person who's creating the will. We're going to have two witnesses. The two witnesses should be uninterested parties. So that should be people that are not receiving property under the will. That's just, in case there was a contest involved, that, you don't want anyone asserting any undue influence by one of the witnesses or beneficiaries. Then there are going to be a notary who should also be there, and the attorney who prepared the documents is normally there. They don't have to be there, but they're typically there to make sure everyone understands what is going on.
And to put a little bit of a caveat to that answer, that is the New Jersey process, right? There are 50 states in the country. Each state has their own requirements. So you want to make sure that you're following the requirements set forth in your state. Because if you executed a will properly in New Jersey, it doesn't necessarily mean that that's the same execution that has to be followed in the state of Washington.
Correct.
Okay. Several people are answering this. I'm going to put you both on the spot here. And I know you can't give an exact answer, but they want to know what the average cost, general range would be to create a will and do something. I know it all depends on the extent of it that people are asking.
Right. So, we do things on an hourly basis. Maria's rate is, $375. I'm right around $300 an hour. But you know what, for a simple estate plan, it really ranges to the extent a simple estate plan exists. If I can coordinate effectively with the client and get all the information I need quickly and put together the documents in a timely fashion, you're looking at, $1,200, $1,500 for wills for a husband and wife, powers of attorney for both, healthcare proxies for both. It could be a little bit less. If we get in the weeds and we, start having a lot of back and forth about how things are going to go, then it can be more, obviously.
Right, and as we've covered before, there are probate assets and non-probate assets. So you may have a situation where it's really a simple plan because in sitting down and looking at all the applicable assets and documents, we've decided that most of your transfers could be accomplished through non-probate assets, and we'll just put together a very simple will to kind of capture whatever else doesn't fall into that category, and that could be even under $1,000.
It could be, yeah, absolutely.
Yeah. Great, thank you.
So it really varies depending on your circumstances.
Okay, now somebody asked, I'm going to put this together, and the executor of this person's will is elderly. What happens if an executor dies first, and what happens if a power of attorney passes away?
Right, so that's actually an excellent question. Usually we suggest that in all documents you name an executor and also an alternate, right? So same thing with executors, trustees, and power of attorneys. So if for some reason the executor or whoever is unable to serve, there's always an alternate who can step up and serve.
And if that individual who asked that question, does have an executor that is up there in years and for whatever reason in their will does not have a successor, that is something that they should, really consider, because if you have a will that doesn't name an executor that can act, you're going to wind up making an application to the probate court to get that admitted and have someone else that you haven't specified as an executor named so.
Right. So ultimately, if you don't make that decision and if you don't name an alternate, the circumstances of the court will appoint one for you.
And that doesn't mean it's going to be someone outside of your family,
right,
but it's just going to mean that it's going to take a couple of months to get the estate opened. You may need to hire an attorney to make this application for you. So like I said, it's going to fall into the category of circumstances that are going to have unnecessary legal fees and unnecessary delays.
Right. And I think
previously.
And I think this really underscores what John mentioned earlier, right? That people who are of average means, we're talking about middle class, have the most to lose.
Yeah, exactly.
Because if you don't have alternates and you have to make any application to the court, what you will see is a significant delay in getting things moving for your estate. So let's say you own a house, right? And let's say you don't own it outright. You still have a mortgage that you have to pay and you still have taxes that you have to pay. There may be like a 2 months delay before you get someone appointed to act on your behalf. But in the meantime, you are still incurring those expenses. So it's costing your estate money, which could have been completely avoid it.
Doing these carrying costs where, in the alternative, you could have just had the house in the market.
Right, almost immediately.
Yeah.
And those expenses could have been avoided. And again, an application, so while a cost of a will could range, up to like $2,000 if it's a complicated, or even more if it's a complicated one. But let's say an average cost somewhere between $1,000 and $1,500, right? That's for your estate plan to be prepared by a qualified professional. Making an application to the court to serve as an administrator or making a guardianship application could cost you $5,000, $7,000, and that's in the event that those are simple applications that are not challenged by anyone.
Okay, I'm going to ask one more question. There are more questions, Mariya and John, but if it's okay, can we send them to you? People can. Yeah.
You can definitely send them to us, but what I would strongly encourage is that if anyone has any questions that weren't answered now, even though they were sent to us, reach out to us on your own with the details and the question, and then we will respond.
Yeah, because they're getting things like, documents with an executor and alternate, and then the executor passes away, you need to redo. So, but one question I do want to ask, it's kind of combining two questions that somebody asked. Oh, can you hear me?
No, you're just spacing out a little bit.
Okay, somebody, I feel like I'm echoing. I was going to combine, okay, I'm good. I wanted to combine 4 questions that people asked. Somebody said, can you deny something that's left to you in a will if you feel like it's going to impact you financially in a negative way?
Yeah, sure. You can disclaim an inheritance, absolutely. Actually, there is such thing as a disclaimer will, where we give spouses or any beneficiaries the right to disclaim any property should it affect them, whether it be a beneficiary receiving government benefits, or if it's going to put a spouse over the tax exemption and incur additional taxes. You can absolutely disclaim something that's been left to you in a will or a trust.
Yeah, but also that goes back to our initial conversation about planning and trusts and special needs trusts and all that other stuff. If you have conversations, these are the conversations you should have with your family, by the way, right? So if you're in circumstances where you think that it's going to affect you negatively, maybe a trust is the way to go. Yeah, again, it's really very specific, but you absolutely can disclaim an inheritance.
Thank you. Those are the exact things people said: taxes, medical benefits, Social Security, things like that. Okay.
Yeah, absolutely. Yeah. So there is a way, there may be a way for you to have your cake and eat it too, right? Yep. So as we mentioned before, there's special needs trusts, Medicaid planning trusts, all of that stuff could be done so that everyone's wishes are kind of balanced out with what the laws are. And by the way, all of these planning tools are 100% legal. Provided you go to an attorney who knows what they're doing and they do it in the proper way, this is all part of legal strategies to minimize your tax liability and legal strategies to maximize your eligibility for various benefits.
Perfect. Okay. We have so many questions that I'm going to just encourage everyone to reach out. Can you tell me, where are you located?
We are in Montvale, New Jersey, but right now we are not physically in the office given the social distancing requirements. But we are available remotely. We're working remotely. We can hop on the phone with you and have a conversation and really figure out how to best achieve your needs and accommodate whatever your location is.
And can you give us your website?
Yeah, you know what? It's bdlaw.com. So the ending of our emails, the host, I guess, of our emails following the @ is the website, bdlaw.com.
Okay, perfect. Okay, I'm going to end now since we're way over time. And I just want to thank you both. I apologize to anyone here for the sound in the beginning, but it really worked out well in the end. Thank you for your suggestions with the microphone, Stephen. And thank you, Mariya. Thank you, John, for doing this. I think we could stay here for another 2 hours asking questions.
Definitely.
I will encourage everyone to please reach out to Mariya and John if you have questions. Can they say, oh, I was on the webinar, or, blah, 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 whatever they can say like that? Is that
okay? Absolutely. Yes, absolutely.
All right. So thank you, everybody.
All right. Thanks, everyone, for listening.
and we will see you again soon. Thank you.
Thank
Guys,
you.
thank you. Stay safe out there.
Bye.
Bye.